The Arizona Court of Appeals considered the issues presented by the case of Hart v. Hart. Michael Robert Hart was granted sole legal and primary physical custody of the minor children he shares with Carrie Hart, with an additional order that mother's time with the children was to be supervised. At the time of the divorce in 2003, mother was awarded sole legal custody and primary physical custody of the children, followed by her remarriage and relocation with the children to Texas in 2005. Father's relocation for 6 months to be near the children in Texas, father's return to Arizona after not finding steady employment, mother's separation from her new husband, and her subsequent move to an apartment with the children. Father filed a petition for mediation seeking physical custody of the children in June of 2007, followed by a petition to modify custody. He also filed a petition for temporary orders allowing the children to remain with him in Arizona to start school. The subsequent hearing was conducted on August 14, 2007, and the children returned to live with their mother in Texas in August. The court then concluded that it'd be in the child's best interest to live with father in Arizona and for mother to have supervised parenting time during summer and school breaks. Mother filed a motion for reconsideration, arguing that there was a lack of evidence and that the court failed to present findings regarding relevant factors. The court denied the motion without comment. After her motion was denied, she appealed that order. In making a child custody decision, the court is required to consider the factors that are enumerated in Arizona Revised Statute Section 25403 in regards to the best interests of the children. In a contested custody hearing, the court must make specific findings regarding all relevant factors and the reasons that a modification of a child custody order is in the best interest of those children. Failure to make the necessary findings equates to an abuse of that trial court's discretion. The Arizona Court of Appeals, in reviewing the decision of the family court, did not find reference to any of the 10 enumerated factors required to be addressed by the court. Relevant facts were noted, but no findings of fact were made regarding the applicable factors, which include the wishes of both children and the parents regarding custody, the interaction and interrelationship between children and each parent, the adjustment of the children to their home, school, and community, the physical and mental health of the children and the parents, which parent is more likely to provide frequent and meaningful contact with the other parent, which parent has a history of providing primary care for the children, the presence of coercion or duress in obtaining a custody agreement, and whether there were any false reporting of child abuse or neglect. The family court did not document the weighing of statutory factors with findings as required by that statute. The Arizona Court of Appeals must consider the possibility that, had the trial judge done so, it may have resulted in a different outcome in the case. The Arizona Court of Appeals also found that the order for supervised parenting time on the mother's part was based, as stated in the court's order, on the best interest of the children. The Arizona Court of Appeals found that the Arizona Revised Statute Section 25410B requires more than just the best interest standard to permit a court to order a parent's parenting time to be supervised. The trial court expressly stated that the standard it used to support its decision to order supervised parenting time was because it was in the best interest of the children, which is the wrong standard of proof. Instead, the trial judge was required to make a finding that unsupervised access placed the children at risk for serious harm before a trial court may order a parent to have supervised visitation with his or her children. The Arizona Court of Appeals vacated the custody and supervised parenting time orders and remanded the case back to the family court judge to issue additional findings of fact and conclusions in accordance with requirements of the law.